Afternoon, everyone.
Hi there.
Hi, can hear you. I think we might be live. So thank you. Thank you for the confirmation. So we can start. Yeah, good afternoon, everyone. My name's Dario Milo. I'm a media lawyer in South Africa where I practice at Wentzel Attorneys in Johannesburg. I'm also a member of the high-level panel
Dario, if you can hear
on
me. I think I could kind of hear
media
him in the
freedom.
background. Oh, here we go. Sorry, Dario.
Can you hear me?
Now we can hear you. Yep.
Sorry. Okay. Let me start again. My name's Dario Milo. I'm a media lawyer practicing at Wentzel in Sandton in South Africa. I'm also a member of the high-level panel of legal experts on media freedom. And one of the issues that we are looking very closely at is both in my practice and, of course, on the high-level panel is the phenomenon of SLAPPs. I'm joined by an incredibly exciting panel today, and I know that you've been discussing UK developments, and we're going to now move our focus to international developments and how SLAPP proposals are being implemented around the world, in particular with a focus on Ireland, on the United States, and then we'll also look at what's happening in the European Union and the Council of Europe. I thought I'd also just start and abuse my position as moderator just by updating you a little bit on the position in South Africa. Since we spoke last year at this panel, last year I mentioned that our constitutional court, which is the highest court in our system, had ruled in a common law defamation case that there is a anti-SLAPP abuse of process defense available. And that was necessary because we don't have legislation in South Africa. Although I must say, I'm happy to report that a draft model law is being proposed, and hopefully that will be launched in the next few weeks in South Africa. But the Constitutional Court case has resulted this year, that was last year, but this year it's resulted in a number of court decisions where judges have and litigants have used the defense and argued the defense. And in one particularly important development that I'll just mention briefly, because I think it does actually tie in with one of the topics we might discuss in the panel. In one development, in fact, in a private prosecution, criminal prosecution brought by former President Zuma against a court reporter, the court reporter argued that this was a SLAPP, and President Zuma said the development in the Constitutional Court only applies to civil cases. And our courts here, our full bench, held that, in fact, the anti-SLAPP abuse of process development in our law applies also to criminal law, and perhaps even more importantly, more significantly, to attempts to use the criminal law to stifle criticism. So that was a very important development a few months ago in South Africa. And perhaps with that introduction out of the way, I'd like to introduce our panel, and I'm sorry that I can't be there with you in person. We have really phenomenal speakers here. Corinne Vella, who's the head of media relations for the Daphne Galizia Foundation, and she will start us off very soon, perhaps with a bit of background on Daphne Galizia's role in the anti-SLAPP movement and her legacy, and also take us through some European Union developments and where we are at with the anti-SLAPP directive. We'll then speak to Flutura Kusari, who's well known as well as an anti-SLAPP advisor and expert. She will reflect on hopefully some of the comments made by Corinne, and also talk about the Council of Europe developments and what's happening in that context. I'd like to then move to Jessica Mhainín, and I hope I got your surname correctly pronounced, to talk about the Republic of Ireland and Northern Ireland and the developments in those jurisdictions. And finally, Laura Prather, also an expert in this area of law from the United States with vast experience, who can talk about the federal anti-SLAPP law, as well as where that's at and how a number of states are adopting anti-SLAPP laws in the United States. So perhaps without much further ado, except to say that if you do have questions, please put them into the into the chat box if you're online. I will then ask those questions a bit later. If you're in person, then I'm very happy to say that Jessica has kindly agreed to call on people who want to participate and who have questions a bit later. So thank you for that, Jessica, for playing that role. It's a bit difficult to do online. Karine, perhaps you can start.
Sure, thank you. Well, thanks everybody for being here. I hope you can hear me. There were a few technical hitches, but I guess I'll get a shout if it's not working. So as Darius explained, I work for the Daphne Caruana Galizia Foundation. That's a foundation set up by my sister's family after she was killed in October 2017. And at the time of her death, she was facing some 48 libel suits, 5 of which were criminal defamation. And she was receiving threats on a regular basis from a company that used to sell Maltese passports, and a threatening action in the UK on the grounds that it would frighten her into silence because it's so expensive to defend a case there. The fact that she faced so many lawsuits only became known more widely than in Malta when she was killed. And it is because of her death, to some extent, that there has been such a strong movement towards ending SLAPPs in Europe. It is the first time, I think, that so many people in so many organizations and so many places have gotten together to work towards ending SLAPPs, and that formed the Coalition Against SLAPPs in Europe. The law that we hope to see in the European Union, the EU Anti-SLAPP Directive, is colloquially known as DAF.
Can't hear you, Dario, I'm afraid.
I think we've lost Karine on my side anyway. We got a technical problem with the link to her. Okay, I think well, let's try and work on that technical link. And while we do, I wonder if Flutura, if you'd like to come in. I think that Karine was going to set the stage for where we are at the EU, and perhaps you can set the stage for us and also talk about the Council of Europe. And for those who don't know, what the difference really is between these two initiatives in Europe.
Yeah, thank you. I was given 5 minutes to present 3 instruments. I'll try my best. So the what we see now is that all European institutions, the European Parliament, the Council of Europe, and the European Union have reacted to the case, to Coalition for Anti-SLAPP in Europe, which is a result of the movement that basically started after Daphne was assassinated. Cora was already saying that she faced a lot of lawsuits. A small group of civil society activists, many of them here, started to discuss with each other whether there was something that we could do, whether this was a problem in many countries. And the result is now that we do have some instruments. First and foremost, on 27th of April in 2021, the European Commission launched a proposal for Anti-SLAPP directive. As members of CASE and also our individual organizations, we welcomed. It's a very strong proposal with some key safeguards and remedies. It covers mainly civil matters. Strong aspects of the directive are the strong definition of cross-border matters, early dismissal, reversal burden of proof, stay of proceedings, accelerated proceedings, a regime of sanctions which is being proposed, compensation of damages, and protection against third country judgments. What the directive also proposes is to have a sort of holistic approach, because it gives some guidelines to member states, inviting them, for example, to abolish a prison sentence for defamation, to introduce rules on support mechanism, to review ethical codes regulating lawyers, data collection, etc. We name this informally as Daphne's Law because it's a result of the work that was done after Daphne was assassinated, and it was very much welcome, as I said. There are concerns about the proposed directive, but I'll come back to that maybe in the second part of intervention together with a timeline. The second instrument is the Council of Europe recommendation, which has been already drafted by the Council of Europe. I'm a member of the expert committee, and of course I'm biased when I talk about this instrument, but we've tried to collect and reflect on the best input we had from across Europe. That was the work that was done before the expert committee was established, but also during consultation. Throughout the summer, we received consultation from a lot of organizations, individuals, experts, etc. So what the current draft covers all legal actions, which is very different from the directive. It covers civil, administrative, and criminal actions, but it also covers legal intimidation tactics, including threatening letters, which are received before a lawsuit is filed. And we heard from the previous session how important that is. Another feature that we hope member states, we hope it will help member states, is the SLAPP indicators. We've provided a list of indicators which hopefully will help judges but also administrative bodies to recognize a SLAPP. This is a discussion that we've had throughout our campaign in the last 5 years, how to recognize a SLAPP lawsuit. So there is a list of indicators. I don't have time to go through it, but very happy to share it afterwards. It's also online. We call on member states to pay a particular account to various types of SLAPPs. So I identified 3 types of SLAPPs: cross-border SLAPPs, multiple or coordinated SLAPPs, and also SLAPPs targeting anonymous public participation. The most important aspect of this recommendation, if it is adopted by the Committee of Ministers, that it calls member states to provide national anti-SLAPP legislation, self-standing laws which address SLAPPs, which would enable SLAPP targets to invoke SLAPPs when there are indicators that a particular lawsuit is a SLAPP. UK, it has been mentioned, UK is the first country in Europe to provide provisions on anti-SLAPP. It is not enough, we heard, but it's a very good start, and it can be used also as an inspiration for other countries. The recommendation has a long list of various procedural safeguards and remedies. Early dismissal as being one of the strongest and the key procedural safeguards. We've heard a lot in the past how important it is to balance the right to access justice, but also the right of SLAPP targets to protect themselves. And the early dismissal mechanism is one of the strongest mechanism for SLAPP targets. Yes, if somebody believes that it has been defamed, he or she has a right to go to court, but also courts should be equipped so that these cases are dismissed as early as possible. And then security for procedural costs is also foreseeing cost shifting. There is also a particular aspect in the recommendation which is connected to death or a loss of legal capacity of a SLAPP victim. So what we're proposing is that the defense in place for SLAPP targets is then transferred to, and I'm simplifying, it's transferred to family member in case a SLAPP target is killed, assassinated, or is dead. And this is very much inspired by Daphne's case, because, as you know, the family is still struggling to represent her work in the court. And then remedies, awards of procedural costs, capping of damages, support for targets, and the support that we've designed, hopefully it will get adopted, is very specific. We've asked member states to provide legal support, financial support, and also psychological support for journalists. One of the recommendations that we've received while we were working was the importance of courts being able to acknowledge the status of a SLAPP victim. And this is also foreseen, which hopefully then it will make it to national law. Now, just to conclude on the Council of Europe recommendation, we've worked for 2 years on this. It reflects very much the Convention, Article 10, and other related articles, the European Court of Human Rights case law, as well as many recommendations of the Council of Europe. I'll get back in my second intervention with regard to timeline and what is expected next. And the third instrument is the PACE resolution. I don't know why I'm sharing this with you, because we have the author here, Peter Nordlander, who drafted the resolution, but I was tasked to do it. It's a very strong document. As you know, PACE resolutions, sometimes they have this very diplomatic language. This one is very strong. It asks basically the Committee of Ministers to put in place procedural safeguards and remedies. And it asks the Committee of Ministers to put in place a bold anti-SLAPP recommendation. So even if the draft recommendation itself is not enough to convince member states that this is the way forward, the PACE resolution will really help convincing member states. So by the end of hopefully summer next year, we'll have these instruments in place, and then is the implementation stage, but I'll talk about it a little bit later. Thank you.
Thank you so much, Flutura. And in fact, we have Corinne back, and I hope that the link is now working properly, Corinne. So just to put you in the picture, Flutura has, I know you were going to focus on the EU draft directive, and Flutura has touched on that very briefly. But so I think we'd love to hear your thoughts on the directive, as well as you were telling us about your late sister's legacy in this context as well, and the various threats that she was facing.
Yeah, I'm not sure at what point it cut off, but I hadn't noticed at the time. So just to do a quick redraft. So Daphne was facing 48 lawsuits when she was killed. She was being threatened by a private company involved in passport sales, threatening action in the UK because it's so expensive. She would have found it very difficult.
Can you check if you're muted? Because we can't hear you.
I don't know.
I'm
not sure what the problem is, but
we can't hear.
I'm sorry.
Oh, no, yeah. You're in. Maybe you can start from the beginning. We couldn't hear you initially.
Right. I'm not sure at what point. Can you hear me?
Yes.
Yes.
Yes. Okay. I was talking about Daphne's experience. At the time she was killed in October 2017, she was facing 48 libel suits. 5 of them were criminal. And it was a murder that drew a lot of attention to the problem of SLAPPs in Europe, because a lot of people outside Malta didn't know she was facing so many cases. And here in Malta, a lot of people didn't know that such a thing called a SLAPP actually exists. The law known as Daphne's Law became known that way because Vera Jourova, the Vice President of the European Commission, had met my mum, was totally aware of the problems that Daphne had been facing, had spoken to my mum and promised her that she would do something to protect journalists in Europe. Hence her work in that area to defend media. When she announced the Anti-SLAPP directive in April 2021, she also said she had wanted to call it Daphne's Law, and it's been known colloquially that way ever since. The backdrop to that is all the work that the Coalition Against SLAPPs in Europe is doing. And that coalition formed a few years ago, and Flutura Kusari is one of the people on the steering committee. Has done a lot of work in that direction. The directive that Flutura mentioned, that draft, which was announced in April 21, was endorsed by the Parliament. It obviously has the endorsement of the Commission, which announced it in the first place, but unfortunately doesn't have the support we want to see from ministries of justice in the Council of the European Union. The position that the Council of the European Union took is very, very weak. It actually hollows out the directive and makes it totally ineffective. A narrow definition of cross-border, which wouldn't capture 90% of the cases identified so far. The broad definition of cross-border would reverse that statistic, so that most cases in Europe would be covered. The the council's position was that the early dismissal mechanism wouldn't really be there. Our minister says that they want to introduce an early dismissal mechanism, but what we've seen so far is so weak it would be totally ineffective and, you know, totally defeat its own purpose. So there are weaknesses there, and this is the challenge with the directive, is that the ministers of justice of the European Union are the ones who have to make a change. They have to improve the strength of their own position. They have to improve on what they've originally proposed themselves to at least, very least, meet what was originally proposed as the directive. In 2 days' time, there will be the final trilogue on the draft directive. We do not know exactly what is happening there. We don't know what the final outcome would be. What we do know is that unless we have an early dismissal mechanism that is worthy of its name, a cross-border definition that is really, really broad, that to capture most of the cases that occur in Europe, and some standard-setting compensation mechanism for SLAPP targets, then we will have a directive that is much less than we had anticipated. So we're hoping to see a much stronger position taken. The Minister of Justice, Högling, has presented laws, you know, supposedly to address SLAPPs. They have not been enacted in Parliament. They're just presented in the House, but because of the public outrage about the weakness of the proposals, they've been suspended. And hopefully the directive itself will set a much higher standard that Malta itself will have to meet. And then we will finally have a law that is worthy of being called Daphne's Law.
Thank you so much. Thank you so much for that, Corinne. Perhaps segueing from that through to Jessica on the position in Ireland, which is somewhat complex because of the position of Northern Ireland versus the Republic of Ireland. Jessica, would you like to talk about that?
Yeah, sure. Thanks, Dario. Yeah, I suppose the island, I'm talking about the island of Ireland. So we are talking there about two jurisdictions, which is of interest here today because since we're talking about the EU, in the Republic of Ireland, it's in the European Union, and Northern Ireland, it's in the UK. In the Republic of Ireland, defamation reform was well overdue by the time the government published its report on the review of the Defamation Act in 2022. And now the bill is due to be published early next year. There's been a lot of discussion around SLAPPs in that context over the last number of months, but the issue that has really dominated the discussion has actually been around juries. The government had declared its intention to remove juries from defamation cases, but it's been met by quite a bit of opposition. Just a few weeks ago, the Justice Committee dedicated its first 4 recommendations to calling on the government to maintain juries. So Index has actually just put out a report on that today, which might be of interest if people are interested specifically in juries and defamation cases. But yeah, in terms of specifically the SLAPPs proposals, they are very encouraging. We were really encouraged to see that they were included in the report that the government put out, and they do include, you know, an anti-SLAPP filter, which is an early dismissal mechanism, basically, that is so important. But we have urged the government to go further. So we Index works with a coalition of organisations as well that are based in Ireland, both north and south, NGOs, academics and lawyers and so on. And we have urged the government to ensure that the legislation would be applicable to ongoing cases as well, so not just going forward, but also looking backwards at the cases that have already been filed, and also for defamation to be eligible for civil legal aid, which is obviously something that we would love to see here as well. And of course, unfortunately, this legislation and this anti-SLAPP, the anti-SLAPP measures therein will be only covering defamation, SLAPPs with regard to defamation, but we're hopeful, obviously, given that Ireland, the Republic of Ireland, is in the EU, that obviously we'd have a strong enough directive that would cover other laws, including privacy, which we also see. Then looking briefly to Northern Ireland, even though Northern Ireland is in the UK, it's not covered by the anti-SLAPP amendments, which we heard about earlier. So there's no protections there from the amendments in ECB2, nor to Scotland for that matter. And so they need to bring forward their own legislation. The Defamation Act 2022 came into effect just last year. There was a new Defamation Act in Northern Ireland. Quite fortunately, the drafter of that legislation put in that it would be up for review after 2 years. So that's already coming around next year, and the review has actually already started. So the administration there is calling on stakeholders at the moment to engage, and they're calling for them to engage also on SLAPP specifically, which is really encouraging. So that's something that we'll be doing over the coming weeks before the end of January. I thought it might be interesting. I think, you know, you'd be forgiven, given that Ireland is such a close neighbour, especially you know, Northern Ireland being in the UK in particular. You'd be forgiven for thinking that there's a lot of similarities between England and Wales and Ireland, and there are certainly. Obviously, it's a common law jurisdiction as well, but there are also quite a few differences. You know, in the Republic of Ireland, there's also a constitutional issue there around, you know, the balancing of rights. Obviously, that comes in under the European Convention as well, but there's kind of an extra step, and people have raised questions around whether an anti-SLAPP mechanism would interfere with kind of constitutional rights around good name. But also to name just a few other issues. One is the issue of lay litigants. There's a lot more, we see a lot more lay litigants given there's also a practice by solicitors to take on cases on a no-win, no-fee basis. So we have kind of lay litigants who are sometimes going after perceived, deep-pocketed, and I say perceived, media outlets, you know, traditional media, in the hope that they can just get some money out of it. So they're not, you know, going after public watchdogs in a SLAPP way that we would see in terms of looking to silence them, but still quite concerning and quite fastidious, obviously, for media outlets, because it can take still some time and money, and it can just make the issue around SLAPPs just a little bit grayer when we're looking at defining them or finding them. Also, there's less of an industry around SLAPP, so we see a lot more of a diverse range of law firms engaging in the practice. One lawyer said to me that they tend to be kind of bottom feeder firms. So again, you know, we don't see the kind of same names coming up again and again as we do in the UK. The types of cases are also different. You know, not so much on corruption and economic crime, but a lot more from politicians. Peter Geoghegan this morning mentioned some of that, and certainly last week Index and several of our partners wrote a letter to Sinn Féin's president, Mary Lou McDonald, regarding the legal actions that members of her party are taking against the media. We believe there's approximately 9 or 10 current legal actions that members of the party are taking against the media right now in Dublin, but also in Belfast. So that's something that's really of concern, especially at a time where that party is under rightly a lot of scrutiny in the lead up to an election where that they're widely expected to win. And fourthly, and maybe kind of most importantly, and this was referred to also this morning, is the kind of space that we're in the UK at the moment, which is really encouraging, where people are speaking about the issue, and people are. David Hooper mentioned earlier about the letter that you know, that he received, the threat, and now it's on private eye, and that's something that isn't really happening so much in Ireland, and I think in other jurisdictions as well. There's not that kind of culture of speaking out about it, and that's something that we really need to try to address, because we can't really make any progress if people don't speak out about the issue. Of course, we recognise that's incredibly difficult. It's not that easy to do, but the solidarity, working together and kind of having some unity is something that's really encouraging, and also something that Peter mentioned this morning, the kind of Fleet Street and coming out about, you know, speaking out about it. That's not something that we see as much there. One media outlet I was in touch with recently said that they prefer to keep their distance from us and that they don't speak about it. And of course, coming to jury trials, that's also something, you know, people are afraid of speaking out in case they would be held in contempt of court, which would be without precedent, but something that still many people consider to be an issue. Yeah, I think those are probably the main things that you know, in terms of implementation that we are coming up against. One thing though that I would like to mention, just in terms of the scale of the issue and comparing the two jurisdictions, comparing Ireland with the UK, I suppose, is that last year was revealed that the Irish National Broadcaster, RTE, had spent 4.7 million on defending 29 separate defamation actions over the previous 6 years. And when we filed an FOI to the BBC, we realised that that compares to approximately £965,000 for the BBC, a much larger institution, during the same period. So we talk about, you know, the high cost of defending legal cases in the UK, and that certainly is the case, as we know. But I think it speaks to the scale of the issue in Ireland as well. You know, 4.7 million euro spent in 6 years on defamation cases. Obviously, we can't know how many of that you know, related to SLAPPs specifically, but I think it does give an indication of the scale of the issue for sure.
Thank you so much, Jessica. And I heard you mention David Hooper's name. Just a shout out to him. I really enjoyed the book, Buying Silence, which I'd recommend for anyone who to anyone who's interested in this area of law and this area of activism. Laura, we've spoken on numerous panels together in the last year and a bit, and you have an extremely important perspective, because the United States at once is, I think, probably the jurisdiction which is most well developed in terms of its anti-SLAPP statewide law, but yet there are important developments going on at the federal level. So perhaps you could take us through that.
Sure, Dario, I'm happy to. We actually have developments at both the state and the federal level. I'll start at the state just because that leads us into the federal level. So just a current snapshot on things at the statewide level. In the US, we have 34 states in the District of Columbia that have passed some form of anti-SLAPP legislation. That is since the Pring and Canaan treatise was published back in 1989, 34 years ago. The biggest development on the statewide level is the fact that the Uniform Law Commission has enacted a model act that they are now working to get passed in every state. So they're focusing primarily on states that do not have anti-SLAPP laws right now. But really the goal is to have a uniform law throughout the US instead of what we have currently, which is really a checkerboard of protection. That uniform law has been passed in 6 different states so far. It had a bit of a slow start due to COVID. It was originally adopted in 2020 and has been now passed in Hawaii, Kentucky, Utah, Oregon, Washington, and most recently in New Jersey. It is on the cusp of being passed in Pennsylvania. But in the coming year, there are at least 8 different legislatures that are looking at passing the uniform law. One of those being Iowa. And the reason I bring up Iowa is because it shows what I mean when I say checkerboard of protection. There is libel tourism going on throughout the US, where people are absolutely taking advantage of filing lawsuits in states where there is no anti-SLAPP protection. So Congressman Devin Nunes has really become infamous for all of the various defamation lawsuits that he has filed against what he perceives to be liberal media outlets. One of those lawsuits was filed against Hearst in Iowa, even though Congressman Nunes, or former Congressman Nunes, is from California. Iowa has no anti-SLAPP protection. They are in the process of hopefully passing a law. But you look at the way in which SLAPP filers are taking advantage of those states that do not have protection. Similarly, and this gets us to the federal issue, and I'm only using former Congressman Nunes as an example. There are plenty to choose from. But the same individual, Congressman Nunes, filed a lawsuit in Texas federal court. I live in Texas. And in Texas, we have a great anti-SLAPP law. The problem is it doesn't apply in federal court. So even though he is from California, he sued a New York media outlet, MSNBC, in Texas to avoid having, in Texas federal court, to avoid having to face an anti-SLAPP law. Because in the Ninth Circuit, where he is from, they actually do apply anti-SLAPP laws in federal court. But in the Fifth Circuit, where I'm from, they don't apply anti-SLAPP laws in federal court, which then leads to the need for us to pass a federal law. That is something that we have been working on here in the United States for 14 years. We have not been able to get one passed, but what we are doing currently is we are working on developing an agreed upon bill that will be introduced in Congress probably beginning of next year at this point in time. We've had a little hiccup with some speakership issues here recently. I'm sure y'all have heard. But in any event, there are three main groups that are working together behind the scenes to agree upon legislation to be introduced in the coming session. Those three groups are absolutely critical because they represent all the different sides of the political spectrum. So we have the Americans for Prosperity, which is sort of seen as more of a conservative group, working with the American Association for Justice, which is the trial lawyers and seen as more on the plaintiff side of things, and then Protect the Protest, which is a group of NGOs representing environmental groups, human rights groups, media organizations, etc. Those three are all working together to develop agreed upon legislation to be introduced with bipartisan support in Congress. We already have a Congressman Jamie Raskin who has been spearheading this issue. He is a Democrat in the Congress, and then in the Senate, Senator Wyden, also a Democrat, has been spearheading the issue there. They are working together to get Republican congressmen and senators to sign on to the legislation as well, so it can be introduced in a bipartisan manner. And in that way, we hope to be able to really sort of foreclose this, what is very now a very advantageous system due to the checkerboard protection for libel tourism. We're trying to foreclose that by passing a federal law and then, of course, getting more state anti-SLAPP laws passed in those states that do not currently have protection.
Thanks, Laura. Just maybe on that, for my own clarity, is the danger potentially of federal law that you might, in order to get that widespread support, be watering down sort of the best practice in say California's anti-SLAPP law, which is also widely regarded as a model to be followed. What's your experience been on that issue?
You know, it's interesting because that is actually something that has come up quite a bit. Those states that have strong laws do not want to compromise their strength at all with the federal law. And so what they put into the draft of the federal law is a provision that basically says, if your state law is stronger, look to the state law if it is applied in federal court. So in the Ninth Circuit, where California federal courts do apply their anti-SLAPP law, you would look to the California law. In Texas, where even though we have a strong law, it's not being actually, utilized by the federal courts, the federal law would apply.
Oh, that's very interesting. I'll be reliant on you, Jessica, as to whether we have any questions from the audience at this stage. But perhaps just to kick everything off with one question, and it's something that's particularly taxing us in South Africa at the moment as we draft a model law, and that is it was mentioned by both Flutura and by Jessica, and that is getting that balance right, and in a way that you can advocate for change around, between the need to stop SLAPPs early dismissal and so on, and reversal of onus provisions and so on, which are critical, and on the other hand, being able to say that the meritorious defamation claimant should still be allowed to sue, and those who deserve vindication should get it. So it's a big question about that balance, and obviously when one get into the weeds of how how the proposals address that and how some of the state laws in America address that. I wondered if you had any general comments as to how you achieve that balance. And I know that the Society of Media Lawyers in the UK recently formed a Society of Media Lawyers for mainly, as I understand it, claimant firms that act for claimants have criticized a lot of the anti-SLAPP activism and potential legal developments precisely on this basis, that there is in a way closing down of access to justice in the reputation sphere. So I don't know if you have any guidance for those of us who are in countries who are starting this process off as to how to get that balance right. Perhaps Flutura, I don't know if you'd like to start.
Yeah, so two comments, one on your question, and one also I just want to share very briefly a timeline of when can we expect these instruments to be approved. I guess one of the most important aspects is to guide courts on how to recognize SLAPPs. This is the question that you get from lawyers, this is the question that you get from judges, from administrative bodies, media councils, etc. And the recommendation, if adopted, should prove very helpful. So what we've suggested, this is very much work that was done by CASE and a lot of international organizations which made it also to the Council of Europe work. So what we've suggested is that we've provided a list of indicators which those dealing with SLAPPs, including lawyers, should check before they take actions. For example, some of the indicators are whether the claimant tries to exploit an imbalance of power, such as their financial advantage or political influence. The other one is the arguments put forward by the claimant are partially or fully unfounded. This is a whole discussion in itself, but we've seen cases when sometimes a lawsuit has some merits, but then you see the damages that are being requested, which sometimes are 1 million, 2 million and more, then you see that also could be considered as SLAPP. The remedies requested by the claimants are disproportionate. The claimant's abuse to amount to abuse of laws or procedures. We've seen a lot of cases when the claimant engages in procedural and litigation tactics so that the cases are delayed. For example, we had a case in Malta, a Bulgarian businessman operating in Malta sued a journalist and a media outlet in Bulgaria. Not only he sued them in Bulgaria, but he sued in a court which was not in Sofia, which meant for journalists and the media outlet to spend half a year in informing the court that they are not responsible, etc., which in the end translated into a lot of costs. So I think this would help, and also if you have an effective early dismissal mechanism. We have a case in France, it's new, I don't have the details, but very happy to share it afterwards, where the court reacted very quickly and dismissed the case. I'll take the information while we're here and share it with you, but there are cases when the early dismissal mechanism can prove very helpful. The second point on the timeline. So the directive, and it was mentioned also by Cora, it was suggested as a very strong instrument, but then when it entered into the machinery of the EU, it was weakened. We have now what is called a general approach, and the general approach is basically a starting point for the trilogue discussions. And there are aspects of the directive which we hope will remain strong, and the most important ones are the early dismissal, the cross-border matters, and the compensation of damages. If we don't have a directive with strong elements on these three aspects, it will not help SLAPP victims. We expect and we know that the Commission is working hard to adopt the directive by April, and hopefully they will manage while we have this composition of the European Commission. But we'll have to see. On the Council of Europe recommendation, we were told that it might be adopted by February next year from the Committee of Ministers. Next week, it will be before the CDMSI, which is the committee that approves the recommendation to go to the Committee of Ministers. Hopefully there will be no changes there, and the resolution of the PACE will be adopted by April. So what does that mean? It means that by early summer next year, we'll have the first European standards on anti-SLAPP. And then it will be time for implementation. And for the implementation to be successful, I believe that there are two elements which are important. First and foremost, political will. And we've seen this in UK. If you don't have politicians who take media freedom seriously, who believe in human rights, we will not see these measures implemented. And we've seen this with the protection of whistleblowers. You have still countries within EU which have not put forward legislation to protect whistleblowers. And the second element is the inclusion of civil society. You have countries now, not to name and shame, but we will at a later stage maybe, which are introducing somehow anti-SLAPP legislation which which aim to protect journalists and civil society members, but they don't want to share this with civil society. They don't want to engage civil society in the drafting process. And then the result we see is that the proposed legislation is not even close to the standards that are being set up. And sometimes it does the opposite. So including civil society from the very beginning is really key, and it helps the government because the knowledge, the expertise can be shared, and we've seen this example in UK. Thank you.
Thank you, Flutura. I mean, I think not involving civil society would raise suspicions on my side as well. Jessica, I wonder if you had, perhaps if there are questions in the audience, if you could call on anyone who's there, that would be useful. But perhaps also your thoughts perhaps on this balance that you also mentioned between access to justice for those who have a good case. And what I mean by a good case is not just a good case, from a proportionality perspective. They're not suing for millions and millions of pounds or euros or rands and so on. How does one approach that balance at a high level?
I think it is challenging and it is important. And I think that goes back to the filter, I suppose the filter mechanism as well is designed to do exactly that, to filter out the cases that are abusive and to leave the ones that are legitimate. So I don't think that we're in any way saying that people don't have the right to defend their good name, or indeed, the right to privacy as well. Obviously, those are important human rights. It is just that at the moment the balance is off kilter, and that's something that we really need to correct, because freedom of expression is such a fundamental right for holding power to account, and exactly for democracy as well. And that's something that is under pressure right around the world right now. So that's why we really need this. And I think coming to Flutura's point there about political will, it's something that in several jurisdictions, especially those where political parties are responsible for taking the legal actions, it makes the political will point actually quite challenging, because we see the issue of SLAPPs being so politicised. Even just last week in Ireland as well, as I said, we sent the letter to the Sinn Féin president, and afterwards we saw other political parties, doing kind of political campaigns with the hashtag "Don't Sue Me," so it was kind of, driving this like, oh, now we're the party of freedom of expression. In actual fact, we know that there's very few parties that I'm speaking about Ireland, but I think it's probably true of most countries. There's very few parties that have no members to have ever threatened legal action. It's just we're calling out the ones where there's a very clear trend. So, but this kind of politicization of the issue of SLAPPs does make it more challenging as well. So yeah, hopefully that's something that we will be able to overcome when thinking about implementation. But yes, to your question, Dario, about questions, I think I did see, yes, maybe we can, do you want to start by taking questions from the floor here, Dario?
Can I just ask one question before the floor, which has come in online, because it's quite relevant to what we're talking about now, and that is, how can we expect that legislatures will be willing to approve anti-SLAPP legislation when they often the ones weaponizing the law against journalists, so members of parliament? And the example given here is Italy. So I'm not going to comment on the position in Italy, but is there anyone who wants to deal with that? Karine, maybe that's something that you could deal with. So how do you sell this to the very MPs who have been in the past claimants in some of these high-profile slaps?
She's frozen.
Is Karine frozen? Okay.
Can I just briefly say something? So until now, most of the work of CASE was focused on EU and Council of Europe advocacy. What we are doing now is working with national working group, this is how we call, in different countries, so that they come together, they draft model laws, and they push their politicians to come up with anti-SLAPP legislation. This is not always easy. We see some good examples, but most of the countries still need some push, and I think it comes down in the end to the role of civil society and media. The more active civil society is, the more active journalists are in terms of speaking about SLAPPs, asking questions, monitoring what is happening, and reporting. I think that helps in adding pressure. But also we have countries where there is little hope. For example, Slovakia. Now with the recent developments, with the new government, I would be very surprised, if not shocked, if the current government would come up with any legislation, any measure to protect journalists. So all we can do is just try to be active and push for it.
Yeah, I think that is right. Perhaps, Jessica, we can go to the floor.
Sure. Yep, go ahead.
It's Don Staniford from Scammon Scotland. I'm an environmental campaigner. My question to the panel is, do we have a frame of reference on who are the stakeholders involved in SLAPPs? If we look at, like I say, a pie chart, we've talked about journalists, we talked about politicians, and we talked about the tip of the iceberg. So we don't really know how big the iceberg is, but I would certainly suggest that there's lots of environmental activists, animal rights activists who are being slapped and it's not really being reported. So presumably politicians, journalists are the biggest group, or is it because they're the most vocal?
I can start with that one. Yeah, I think certainly environmental, watchdogs, public, when we talk about SLAPPs, we're talking about public watchdogs, people speaking out in the public interest. So those campaigning or calling out issues around environment, certainly an area. We've also seen cases to do with housing, calling out like landlords or, kind of other issues, maybe developers and so on about, issues in that regard. Tomorrow as well, we're going to be hearing about SLAPPs related to sexual assault and harassment. So Nina Cresswell, her case, she was a victim of sexual assault, and she faced a slap from her abuser. So, we're really talking about anyone speaking out in the public interest. We also have been looking at cases where people have been writing reviews, on a review website, leaving reviews there, and that they've been slapped. So it can really affect anyone really who's speaking out in the public interest. But I suppose journalists are one of the main targets. But also I suppose we know about them because they're one of the more vocal groups at the moment. I think what makes it it's obviously not easy for anyone to be subject to a slap, but maybe what makes it slightly easier for journalists than other groups is that they have the possibility of being sued kind of in their peripheral vision. They probably hear about it when they're studying journalism, or they probably touch on the law, but certainly that's not the case for someone who's maybe writing a review about a medical procedure that they've had. They don't realize that this is an issue, and the kind of how easy it is to isolate them is really profound. So that's for us working on SLAPPs across Europe, it's especially important to reach those people who are maybe it's probably slightly easier to silence them.
Yeah, and I think just to add on to that, Jessica, there have been numerous studies and empirical data on on the prevalence of SLAPPs across the UK and across Europe. And Flutura, if I'm not mistaken, CASE has done some very deep dive type research. in terms of the geography of SLAPPs. So I think it's very important that those efforts are documenting SLAPPs, writing up the stories, continue, because ultimately, it seems to me, if you for instance have, and I speak from a South African perspective, if you have the stories of the case studies that are persuasive enough, certainly in our court, in the mineral sands case, which was the Constitutional Court case, we were saying, SLAPP, we need to recognize anti-SLAPP abuse, and the court, looking at examples from other jurisdictions and South Africa, said it's quite clear that SLAPPs are on the rise in Africa. So I think it's important to document that evidence and to keep collecting it.
Absolutely. Should we continue with questions from the floor here, Dario?
Yes, please, if you could.
Great. Yep, that would be great. The lady in the white dress.
My name is Ursula Smart. I author a book on media law, and this is a question for you, Jessica. It's a fact that Northern Ireland and Scotland didn't adopt the 2013 Defamation Act for a long, long time. And Scotland finally passed its own act a couple of years ago. I followed Northern Ireland and the Republic of Ireland as well, which has become a great centre for libel tourism and a sort of cherry picking in the Belfast and Dublin courts. I also know that it's become in Northern Ireland a political issue opposed by the DUP constantly. So just picking up on juries, libel juries have been abolished everywhere else in England and Scotland.
And Northern Ireland now too.
And so why was the sort of why did they continue to insist on libel juries continuing is really my question.
I think it's a really good question. It's one that I was giving evidence to the Justice Committee in July as well, and it was something that they kept coming back to, was the issue of juries, that it was, from one of my colleagues in an academic in Northern Ireland, I had told him in advance it was probably going to be big, and he was coming out saying, I know you told me, but I was still so shocked. We were even having cases, I think one member of kind of conflating, damage to reputation with actually like a criminal, with something as serious as something criminal. I think the seriousness on one hand or the kind of weight that's attributed to reputation is maybe one of the reasons. It's just such a profound thing. On the other hand, I think something that comes up again and again, including by a High Court judge, he said that, and it's going back to the meanings part that Caroline Keane mentioned earlier, right? Is this a reasonable reader? And I think some people say that, well, a judge is a member of the elite. They're not really reasonable. They're not kind of a normal citizen. So some organisations and individuals, including one High Court judge himself, he actually said, well, I was born with a silver spoon in my mouth. I'm not a normal, reasonable reader, so I shouldn't be allowed to make the decision on my own. That's what the jury should be for. So I think there's a number of issues, but those are just two of why juries are still to be included. And I think just to mention that in spite of all that, I think the government will still get rid of juries for defamation cases. They have said so. And in Northern Ireland, so the review, the new Defamation Act that came in last year did get rid of juries in Northern Ireland as well. Have another question here, Dario, as well.
This is either for Flutura or Cora. Obviously, we've seen Daphne's Law or the EU directive get watered down. We'll see what happens with the trilogue when it comes to an end. A lot of us are worried the same thing will happen with the Council of Europe recommendation. The UK Anti-SLAPP Coalition submitted evidence, but a lot of that was to encourage them to continue because it was such a strong draft. What can we do, so people in the room but outside the room, like civil society, experts, et cetera, do to ensure that the recommendation stays as strong as it is at the moment? Because obviously we know it will be, member states, that process. What's your gut as to how we can make sure it stays strong?
Get in touch with your ministers of foreign affairs and ministers of justice in any way you can, with private letters, public letters, protests, whatever works in your own country, and ask them, first and foremost, to be physically present tomorrow. And we've done this with some ministers in Brussels, because tomorrow is 29th, right? Or the day after tomorrow. So on Wednesday, yes. So on 29th is the final trilogue discussion. And unfortunately, from the information that we've had in the last 2 years, a lot of water down of the directive came from civil servants. People, lawyers saying, we have our national law, it works perfectly, we don't need to do changes, although we've documented that SLAPPs are a European problem, and therefore they need a European solution. So in some countries where ministers themselves, they were more active, we saw the result, that they were backing the strong approach, the strong directive, etc. So politicians, it's in the hands of politicians in the EU, but also in the Council of Europe. What we hear now, and we're very positive about the Council of Europe, because they do the standard setting work. They've done it before. They know that when the Council of Europe has to intervene, is a situation when something requires a more collective approach. Plus, Russia is out, which helps a lot. We've seen with hate speech recommendation that the Council struggled very much to adopt it. And yes, if we have some support from civil society at national level, I don't see any problems. So yeah.
Any other questions from the floor?
Corinne, I don't know if you'd like to also add to the last question, or should we move on? I do want to give everyone a chance to make some concluding comments.
We do have one other question here, Dario.
We have time for one more, so one or two more.
Okay, great.
Jessica.
It's Rupert Cooper-Coles from RPC here. It's a question for Laura. We often hear in the debate about SLAPPs that bringing in statutory mechanisms will just increase costs, won't work. It's interesting because you've got 50 examples of laws coming in and how that changes things. But I just wondered whether your experience in the US is that statutory anti-SLAPP laws do make a difference. And is that difference just deterrence, like pushing off the slapper to another jurisdiction, or do these mechanisms catch SLAPPs when people do file in their jurisdiction?
I think it does both. I think that the SLAPP laws do serve as a deterrent, especially once people start to see the way in which they work in the court system. So under our SLAPP laws, the court initially determines whether or not the case has any sort of likelihood of success. And so essentially, we talk about access to justice, right? And access to justice has never meant that there is a right to file a meritless lawsuit. And so what happens is these anti-SLAPP laws actually level the playing field, because once you get into the court system and you demonstrate that really the lawsuit is not about seeking some sort of remedy to a real harm, it's about hijacking the court system to inflict pain on somebody because you don't like what they said or what they exposed, then the court system dismisses the case and the individual who has been sued receives their attorney's fees back and is made whole. The fact that they can be made whole and receive their attorney's fees back is a huge difference in the usual way of doing things for the court system. And it serves as a deterrent to those people that just think, well, I'll go ahead and file a lawsuit because, I may pay a little bit of money for my lawyer, but I'm going to cost the other side a whole lot more money, and I'm going to inflict a whole lot of pain on them so that they don't do this in the future. It's going to, they think that by filing the lawsuit, they're going to deter other people from reporting on them. And when in fact, because of the anti-SLAPP law, they end up having to pay the attorney's fees, that actually serves as a deterrent to other bullies, other people that are were wanting to take advantage of the court system in a similar fashion. And it serves as a deterrent from them doing the same thing. The other thing that it does is it decreases the amount of litigation costs being expended because the case is thrown out early on. And so this really helps the court system to weed out those meritless cases in the first instance. And instead of them taking years to go through the court system, they take months to be resolved. So it's a win-win in the sense that it helps the court system get rid of meritless cases. It makes the SLAPP victim whole, who shouldn't have been on the receiving end of the SLAPP suit to begin with, and it serves as a deterrent for future SLAPP filers to keep them from filing lawsuits that are meritless to begin with.
Thank you, Laura. Jessica, did you say we had another question from the audience?
I think we've covered them. Any other questions?
Okay.
Yeah.
Okay, excellent. Well, I'd like to just have a quick round in the last couple of minutes we have left, just from our panelists. Firstly, to thank all of you for your contributions today, as well as the audience. But if you have any closing remarks, mine would be that I hope if we meet next year and convene next year, we can see that there have been laws enacted in South Africa. In the European Union is draft directive is tightened up and not weakened as we've heard about today. Northern Ireland has SLAPP laws. USA, the federal law is passed, and the model law across the states. So let's hope that we can report on those achievements next year. But Karine, would you like to provide some concluding remarks?
Well, thank you, Dario. I hope there won't be any technical problems at this point. I can only endorse what you've said. I hope that next year we won't have a meeting like this talking about what we want to see, because it will already have happened. And as Flutura said, if you think you want to do something to make sure the laws are as they should be, please do contact your Minister of Justice, contact your Minister of Foreign Affairs. Make sure they know what you, a voter in your own country, are thinking about what they're doing in your name. The biggest group of SLAPP targets are journalists. If they're shut up, how are the rest of us going to know what is going on?
Thank you. Thank you very much. Flutura?
Yes, you said if we meet next year, we're meeting next year on 19th of November 2024 in Strasbourg. Is the second European Anti-SLAPP conference organized by CASE. We will bring between 300 to 400 experts from across Europe. Last year, we celebrated what we achieved in terms of mobilizing the entire Europe about this problem. And next year, hopefully, and we want to celebrate implementation. So politicians across Europe have 357 days to come up with legislation, anti-SLAPP legislation, and to present this in their own countries and to adopt them, and we will make sure that we praise them. And hopefully we will have more civil servants like, and I want to mention Beatrice, we have here Beatrice, who has been very helpful and worked closely with the civil society, and that's why we have the first provisions on anti-SLAPP in UK. We want to have more civil servants like Beatrice, so that we see some examples. So the conference will be about implementation. It's a follow-up of this conference, and we want to track what happens throughout the year next year. And also, sorry, I just want to say I say this regularly and everybody says, but we should just say that personally, I'm very thankful to Daphne's family for and a lot of members of her family are dedicating their life to anti-SLAPP work. Most of us call Matthew every time we want to convince a journalist to speak up about SLAPPs. So I want to use the opportunity to thank Daphne's family, Cora, Matthew, and others for fighting for this cause. It's very important to them, but also to other journalists and activists around Europe.
Yeah, very much. Jessica, final words from you?
Yeah, I think to echo what's been said, but also just to kind of add the note of solidarity. I think it's great that we're all here today, and I think there's been a lot of solidarity among NGOs as well. I think we need to really ensure that solidarity is extended to public watchdogs more broadly. And also just to plug 2 other conferences that are taking place next year. We have a conference in Scotland, which is taking place in February, and a conference that's taking place in Ireland in October, dedicated to SLAPPs. Because I think days like today, where we can all come together, is really important for solidarity, for awareness raising around the importance of speaking up about it. We know it's not that easy, but it is extremely important, and to not treat the abuse of legal actions the same way as, you know, the legitimate ones. They're, you know, we should filter them, we should separate them, and make sure that we're not conflating them. And you know, if you're subject to a SLAPP, you have nothing to feel guilty about. There should be no shame in that. If anything, it should be a source of pride that you're doing your job very well. So please be in touch with us, and we'd love to support you if that's the case.
Thank you so much, and I hope we've diarised all those dates. It's excellent to see all the activity and the momentum that is still continuing. Laura, for you, final words, and then we'll bid everyone farewell from this panel.
I think I'd just like to say, at this critical time when lawmakers are considering what the contours of the anti-SLAPP laws are going to look like in Europe, give them a reason to care. One of the things that we've done in our efforts to get anti-SLAPP laws passed in the US is we've helped them understand the real world impact of these suits on individuals. And I think that the more we can do that, I mean, our law is called the Citizens Participation Act. And the reason it's called that is because this is about everyday citizens. Yes, the media oftentimes is on the receiving end, but that's only because the media is serving as a conduit for the people. Everyday people get sued with these lawsuits. Politicians get sued. We talked a little bit about, you know, why should the politicians want to pass these? Well, sometimes they're on the receiving end of SLAPP suits too. And so the more that we can highlight those instances, that will help give lawmakers a reason to care. And that's just what I would encourage everyone to continue to do such a great job on.
Well, thank you, Laura. That's a really fitting end to give everyone a reason to care. And thank you so much to my panelists on the panel. Thank you to the hosts of this conference. It continues to be a great source of dialogue, but also action. So thanks, everyone, and I hope you enjoy the rest of the day.